Good afternoon, everyone. Welcome to one of our first live webinars. My name is Andrew Aristides. I am part of the team here in Cyprus dealing with customer and business support. And I'd like to welcome you to our webinar today in the subject of classification of foreign companies, onshore and offshore activities, the structure of registration, taxation, and liquidation. First off, I would like to invite you to visit our website, which is eltoma-global.com, and look at all the information we have in regards to company formation, the jurisdictions that we offer. And as today it's about onshore and offshore, you'll see various jurisdictions of Belize, Seychelles, which are tax havens, BVI, and following on you'll see tax payable jurisdictions which have a few more benefits in regards to your business activities or the banks that you work with, such as Cyprus and Singapore. Hong Kong is one of them as well. The method that I'll be delivering our webinar today will be, I found that it's more productive to read out of the slides in order for you to hear the information twice, and further on I'll be elaborating. I'd like to note to you that any questions that you have, please feel free to contact us. We'll be happy to provide the answers. If there's individual scenarios where some research will be required, we'll inform you, and we'll also inform you of how it will eventuate, or if any fees may be payable if we're dealing with some deep research. I'd like to bring to your attention as well what other services Eltoma provides except from incorporation. Well, as we said, incorporation, which is company formation. We also deal with bookkeeping and government reporting obligations according to certain jurisdictions. Bank account openings worldwide. We deal with a vast variety of banks, which can be in Singapore, Cyprus, within Europe, Latvia, and depending if you like to travel or not, we'll advise accordingly. As also one of the most important factors in choosing a bank is your business activities. Another service that we provide is debt collection services, IT services, and legal services. IT services can extend from virtual offices to the structure of service. Website creation is another service that we provide. And as we said, virtual offices that we can provide worldwide. In regards to legal services, we deal with a lot of trademarks these days, liquidations, registration of the companies if they want to transfer from one jurisdiction to another. Therefore, any legal questions that you have, again, feel free to contact us. Eltoma can provide tailor-made solutions for your company needs and formations. Therefore, when you're thinking of making a dream come true and incorporating a company, feel free to contact us and explain to us what you need to make, and we'll provide the options, advise you of the options that you have. And if you'd like to follow them or have questions about them, we'll be happy to provide the answers. Our role in most of the companies is to act as a secretary. A secretary overlooks the company's activities and informs our clients when reporting activities are due, mainly accounting, resolutions need to be passed, and furthermore, when the renewal of the company needs to be made. The importance of a qualified secretary as Eltoma can only be fully realized throughout the requirements of a company. Therefore, I can sit here and elaborate of what Eltoma does. However, after you incorporate your company and open up, and when you go for the bank account opening process, then you will only fully realize the requirements as of today, where the banks are very strict, of a qualified secretary. Our subject today being classification of foreign companies' onshore, offshore activities, the structure, registration, taxation, and liquidation. Let's move on to our subject today. And again, any questions you have, feel free to contact me. As I said, we have a big team here, and we'll be happy to elaborate. Let's move on. The agenda. Number one, classification of foreign companies, company documents, authorized capital. We'll see the authorized capital and how it differs from the issued capital. Offshore and offshore jurisdictions, onshore companies. We'll see the differences between offshore and onshore, and that just basically depends on where you are. grey and black list of countries, nominee services, beneficial owner, who is the beneficial owner and his role, and how he interacts with the nominee services, due diligence and KYC, which other name it as due diligence KYC. However, the basic is one, that regulations, procedures have changed and have to be followed, and that's what we'll explain there. Company tax residency and company liquidation. Company liquidation is a big subject today, as we all see intergovernmental appointments and their interaction, whereas if you close a company in one jurisdiction, in another jurisdiction they can find out. Therefore, it's better to liquidate a company. If you need to liquidate a company, contact us. We have a full legal team that just deals solely with company liquidations. It's not a big process. However, some procedures have to be met, which means the accounting of the company, if applicable for the jurisdiction, has to be made. Let's see our next slide. Now we go into detail. Classification of foreign companies. By its legal form, companies registered in offshore jurisdictions are divided into a closed company, an open public company with limited liability, and a company with unlimited liability. A closed company, as we'll see further down, is basic limited liability companies that everybody incorporates, and an open public company, and the companies that we basically see listed on the stock exchange. Companies with unlimited liability are companies that are like partnerships, where the liability of the members is unlimited. So in an event of a that it goes bankrupt, you can be sued for your personal effects. Therefore, that's why I always say the most popular form of company formation is a closed company. Next slide. We'll see here the differences between open and closed companies. I elaborated on this before a bit, as described in detail in the Companies Act of each jurisdiction. The main characteristics of these types of companies are, in a closed companies, shares are held by a limited group of people and cannot be offered to the public. Liability of its members is determined by the size of the equity share. The share capital consists of shares with a fixed cash collateral. As a general rule, the right of a company's shareholders to transfer shares to third parties without the prior consent of other shareholders or partners is also limited. Therefore, what this says, in a closed company, or in other words, in a private placement, as you might have heard it, is when a limited liability company, so a third party cannot come in and say, I want to buy shares in this, the shares on stock. Number of requirements are applicable to this type of company, such as certain size of share, companies such as certain sizes of share, capital explicit articles of association. In other words, you would have heard this for the public companies, when a stock exchange advises that a new company is going to be listed, they often refer to it as public placement, and an initial public offering is offered to the public in order for them to review if this stock is good or not in accordance to everyone's requirements. An initial public offering also comes with all the requirements of that jurisdiction. For example, in Cyprus, it will have to be approved from CICEC. In other countries, the member that overlooks all these activities could be named something else, like in the UK could be the FSA. Following on, companies with unlimited liability are those companies where directors and shareholders are equally responsible for the debts of the company. The responsibility extends to all assets of directors and shareholders. As I said before, this is why companies with unlimited liability are not so popular. The reason is that in the event that they go bankrupt, you can be sued for your personal assets. Therefore, the most public and available company that's formed today is a limited liability company, as we saw before, and where you can choose who your shareholders will be. Let's see the next slide. The constituent of documents of the company. Within this webinar, we'll see all the documents that are available within corporation, and I'd like to note to you now, and this is a free tip, before you incorporate and before you get prices to incorporate a company, be sure that most of these documents are available and available in a apostille format. In Cyprus, you'll see as we issue them for various jurisdictions, the certificate of incorporation, the memorandum and articles of association, the resolution of directors' appointment, minutes of first meeting, register of directors, register of shareholders, and the share certificate is issued. This is available in the price when we incorporate any company in any jurisdiction. Furthermore, these documents are provided in apostille format. You'll see we get a lot of clients that shop around for prices, and that's with every person's right to shop around for prices through various secretaries to incorporate a company. However, when you see a cheaper price, ask yourself why, because it's a competitive market out there. They might be just listing only that provide a few documents. And on another note, they might just list that they might apostille one or two documents and not all of them. Therefore, it can be cheaper. However, when you go for the bank account opening, or when you see you have to apply to some governmental organization, they will request for all the documents to be apostilled. If you like to know what apostille is, it is the highest form of certification of a document saying that this is a true copy of the original. Now, the originals are apostille and they cannot be disputed in accordance to the Hague Convention. Some countries are not members of the Hague Convention. However, in those certain countries, legalization, which is a more expensive method, for example in Singapore, is available. And when legalization proceeds, that just depends on where you provide it. For example, if you have a company incorporated in Singapore and you have a bank account opening in, let's say, Denmark, and they need the documents legalized, then they will have to be legalized in the embassy in Singapore of Denmark, of the Danish embassy. If you have any questions about these, as I said again, and this is a free tip to all, feel free to contact us and we'll be happy to elaborate on all these. Furthermore, authorized capital. Unauthorized capital is a sum of total of funds, contributions, fees, or shares of the founders, members invested in the company property at the moment of company incorporation for a purpose of maintaining its activities to the extent determined by the Constitution documents. Okay, so let's not let this confuse you. You're going to see a lot of information in here. It's very easy to understand as we deal with it every day. However, if you're reading it or hearing it for the first time, it can be confusing. Therefore, ask questions and we'll answer them. Don't get confused, as all these steps that you're seeing here, Eltoma Corporate Services has teams and we follow up with them and we'll inform you. There's nothing to be confused about these. So the authorized share capital, as seen here, is the initial original capital of the company. Its size is determined in taking into account the proposed economic activity and is fixed at the moment of state of registration. For example, what all this means, very easy. When you incorporate a company in certain jurisdictions, they have a minimum authorized capital, the minimum amount that you have to disclose of the capital. For example, in Cyprus is 1,000. In some jurisdictions, they would like to see that amount pass through the bank account within a certain time frame. Like that 1,000 is passed through the bank account in a monetary amount. Furthermore, after that, we'll see the differences of the authorized capital with the issued capital. Shareholders and authorized capital owners, shareholders of a company can be any legal or natural persons. The minimum number of shareholders of a private held company in different jurisdictions varies from 1 to 3. In basic terms, the Corporations Law Act, which is basically from English law, and that depends from jurisdiction to jurisdiction. However, a shareholder and for a company, it just it starts from 1 to 3. It can go up to 51 for a private limited company, but basically it's all the same. Just depending on the jurisdiction, there might be some variances of the minimum number of shareholders and the maximum. However, just keep in mind that basically it's all the same. The authorized share capital can be registered, issued, and paid. Before we saw the issued capital that we talked about. Further on, we're going to see the 3 differences. So again, don't let this confuse you. We're going to see the differences further down. There is no obligatory deadline to pay for authorized capital in many jurisdictions used in international tax planning. Here's another important note to see in accordance to the international tax planning that you may need. Here we are. These are all the differences: the registered capital, the issued capital, and the paid-up capital. These are the 3 main differences, and you're going to see in here how organizers of this webinar, Marina, who is a lawyer, and she's stipulated all the differences of the 3 types of capital. In a lot of circumstances, people will pay for this as it's not, and it's an informative advice. For you, it's here for you free, as you have paid for your webinar. We'll give you the details, so this is a free tip for you from the webinar. Alright, so registered capital, as we saw before, is a capital specified in the Constituent of documents which the company has a right to issue without additional registration. For example, if we register our company in Cyprus, we say the minimum share capital is 1,000. Therefore, in the memorandum, it will be stipulated that 1,000, the registered capital is 1,000. The issued capital within a registered capital, here we can see that how it's continuing on. The issued capital is continuing on from the registered capital, becomes issued when a decision on the amount to be issued is made by shareholders. Share certificates are issued and the rights and obligations of shareholders are arising, including the right to vote and obligation to pay for shares. Now what this means, the issued capital, very easy. So we have the registered capital of, let's say, 1,000, and we have the issued capital of 500. That means that in this example, it means there can be another 500 that can be left for another shareholder. So the issued capital is just from the registered capital, what has been issued from the original amount. Now, even if you register 1,000 and you want to increase it in the future, that can be done. So if you're in a hurry to register a company, the small details you can leave for the future if the capital requirements are not of a main interest at the start. The next one is a paid capital, and now we're going to see how it connects with the issued capital. Is that an issued capital, issued shares are paid by shareholders. So from here we can see is even if you register capital and you issue capital, it doesn't certainly mean to be paid. As I said before, so in some jurisdictions, some companies' house wants to see this share capital paid. So when we say paid capital, it's within the issued capital and it's paid by shareholders. From this moment, the obligations of shareholders to pay for these shares cease, and only the rights that these shares embody remain. One of the basic functions of a limited liability company is what we say in comparison to an unlimited company, that your liability is only limited to the unpaid share capital. Therefore, if, for example, if you have paid up capital of 500 and you have 1,000 shares issued to your name, in the event that the company goes for bankruptcy, then you only, as you paid your 500, you're only required to pay the other 500. But therefore, it's very easy, and this is the beauty of a limited liability company. If you want me to, I'll leave this up for you, and if you want to take notes or you have questions about these, please feel free to ask us questions. We'll be happy to elaborate on this topic of authorized capital. Let's move on. Next topic. What is offshore? So a lot of people think when we say offshore company or need an offshore, if you think about it, what is offshore? From English offshore, it means away from shore, out of the bounds, so away from home. When we say we're going to incorporate a company, an offshore company, it means that we're going to, for myself, that I live in Cyprus, and I say I'm going to incorporate a company in Seychelles, for example, that is an offshore company to me. People from Seychelles, when they say they're going to incorporate a company in Cyprus, that's offshore to them. When I'm going to incorporate, I live in Cyprus, I incorporate a company in Cyprus, that is onshore for me. So there's a main difference of offshore and onshore. This is some informative information, which is very basic. However, it's needed when you incorporate a company in understanding certain terms. Offshore, which in the parentheses offshore jurisdiction, offshore zone, is a country or another territory where full or substantial tax exemption is granted, providing no business activity occurs in the country of company registration. Submission of annual tax and financial reporting are not required, or such requirements are simplified. Therefore, what this means is when we say we're going to incorporate a tax haven offshore, the tax and financial reporting are not required, or such requirements are simplified. We're going to see further down when we incorporate a company offshore. However, it's in a jurisdiction, for example, as Singapore, accounting requirements are required and audit requirements in according to the structure. Again, don't let me confuse you with this information, just giving you a heads up what's ahead. And I'm going to elaborate, I'll be saying this a lot. Ask me questions. As many questions as you ask, the more certain you'll be of what company you want to incorporate and where you want to incorporate it. Further on, offshore company. Offshore company is a company that does not conduct any business in the country of registration. As we said before, offshore is a company that, for example, I register that it's not in Cyprus. We're using the example of Seychelles. And it goes further on to say, but that I cannot conduct any business activity in the country of registration. If I do that, that means that it's not an offshore company that I have to pay. If I have business activities in Seychelles, then that means I am going to pay taxes in Seychelles. So this is the foreign directives, the foreign direct investment directives for each country. They offer the offshore incorporation, but that does not mean that for local residents that they do not pay taxes. It's only for people that do not live there. If I go and have business activities in Seychelles, that means that I'm having business activities in Seychelles and I have to pay taxes. There is a requirement in those jurisdictions where registration of such companies are permitted. Typically, this is the typical aspects of a tax haven. Taxation of offshore companies in these countries often only a fixed annual fee. However, this is where we can see some variances. When you're going to have a company that's going to have minimum activity, it can be better to incorporate in a country where you will be paying taxes, as this annual registration fees, especially if you need nominees, may be more than what tax will be payable in the country that you have to do the accounting and tax is payable. In some circumstances, there are thresholds and no tax is payable for a certain amount earned. Therefore, talk to us and we'll explain all this. Again, this is a free tip that no one will tell you. You'll go to a company and you ask for an offshore company, they'll just sell it to you like it's on the shelf. Here at Eltoma, we'll look into your scenario and we'll explain the differences of different companies. On the other note, if you already know what you want, that's even better. Then it'll make it a lot more easier. That means you've done your homework on offshore and onshore companies. Offshore is one of the most common and effective instruments of international tax planning. Here's another free tip how international tax planning is done. Let's say, for example, you have a Cyprus company, whereas you pay taxes, and you have a tax haven. One company sells to another a good from where you buy it from. That means it limits the profit on the invoice that you're showing to Cyprus. This is one of the easiest forms of international tax planning. By minimizing the profit from the tax haven to the Cyprus company, less tax is payable. Therefore, again, contact us and we can explain more. So there's your free tip for your webinar. There'll be a few today. Moving on, offshore classification by corporate law. And here we can see the two variances, which is based on the British law, company and case law of the UK and former colonies. So basically, companies that we can see in jurisdictions that are former British colonies or still British colonies, for example, BVI, Cyprus, they've all got the English law and they follow the corporate law. Other jurisdictions that they have their own company law, which is mainly the Roman law. Like, for example, we can see they go by codes. They don't go by cases, which is the distinction between case law and the code of law, which can be in Italy. Next slide, classification of foreign companies, classification by taxation. And here we have our different variances for the companies that we have. Tax havens are BVI, Belize, Seychelles, Panama. Low tax jurisdictions are Cyprus, Hong Kong, Singapore, Latvia. Normal and high tax jurisdictions are USA, UK, Germany, and etc. So I just have a glass of water. Okay, so we're going to see the variances in these countries. We're going to see where tax havens exist. Infrastructure, country infrastructure is very low. So if you go to Seychelles, Panama, Belize, and BVI, and if we go and visit the countries, the infrastructure will not be as rich as high paid tax jurisdictions or low paid tax jurisdictions. Therefore, in one sense, for a business point of view, it may be good for us. However, for the country's point of view, it is better if some tax is payable because that country has better infrastructure. Therefore, we always, depending on your business activities, choose wisely which jurisdiction you go in. As if you go to a high tax paid jurisdiction, then you have a more secure structure of governmental and fiscal policies. If you want me to elaborate on this, I'll be more than happy to do this on a separate basis. Let's move on to our next slide. Comparison of offshore jurisdictions. Here we have the criteria: tax havens, low tax and normal tax jurisdictions. Taxations in tax havens, they do not exist. Low tax jurisdictions will be up to 20%. So this is continuing on from the previous slide. If you ask the question, what do we perceive as high, what do we perceive as low paying tax? Normal tax jurisdictions is more than 20%. This is how we classify them. This is not a worldwide structure. This is how we classify them. So we classify them as low tax, up to 20%. More than 20%, we proceed them as normal tax. The next criteria is bookkeeping and accounting, which in tax havens is required. Here we're going to see these words: obligatory in low tax and obligatory in high tax, normal tax jurisdictions. The audit is not required in tax havens. It's obligatory in low tax jurisdictions and obligatory in normal tax jurisdictions. Here you will ask yourself a question: well, if I have a not paying tax, why should I do bookkeeping? Well, the basic understanding now, especially when it's harder and harder to open up a bank account, or if you need a bank account that it's in a higher rank jurisdiction. For example, I'll give an example of Barclays. They will accept a tax haven. However, the accounts have to be audited. So that's another free tip for you. So if there's a basic understanding that big banks do not accept some jurisdiction, that is true. However, some big banks do accept those certain jurisdictions if the accounts are audited. Therefore, reading bookkeeping not required and audit not required, you have to talk to us in regards to your business activities and for the banks that you want to go for. And we work for low tax and high tax jurisdictions. And therefore, now you can see the comparison and why banks accept to get low tax jurisdictions and normal tax jurisdictions are not tax havens. However, if you do have, I'll stress the point again, have bookkeeping and audit done, they might look into the scenario in accordance to your business activities to be accepted. Therefore, it's good to do your bookkeeping. If you need a quote for that, please feel free to contact me. Even if it's a company that's not employed by Eltoma, we have a full team here on our fourth floor, and there's about 15 accountants here. They'll be happy to do your bookkeeping and provide you a competitive quote. Next slide. Comparison of offshore jurisdictions. We have here following of, this is a continuation of the table before. Criterias, tax havens, low tax and normal tax as we've seen. Filing of financial statement to the tax authority, submission of annual returns. We're going down on the criteria here. Company renewal fees. Company, we'll start from the bottom and work ourselves up. Company renewal fees, as we can see in tax havens, is a must. In low tax jurisdictions, they might not be applicable. In normal tax, they do not exist. However, tax is payable. Submission of annual return to the register of companies. In tax havens not required, and in other jurisdictions it's obligatory. Filing of financial statement to tax authorities not required. In low tax and normal tax it's a must. Again, let me remind you, when we say you'll realize the benefits of a fully qualified secretary as Eltoma, from what I said in the start, only through how the company eventuates. So here we're going to see, you might ask a question to yourself, who will do all this for me to file a financial statement to the tax authorities? This is when I say the secretary will advise you when this needs to be done, and we can do all this for you. All we need is an open line of communication, and we'll be happy to take care of all these as long as your fees are paid and up to date. Moving on. Types of offshore companies: investment companies, holding companies, trade companies, insurance companies, offshore international trusts, companies for holding and management property. These are the types of offshore companies that when they ask for what business activity does this company do. So in any jurisdiction that you write up a company, they'll ask the business activities. We have a lot of clients that sometimes ask, why do they want these business activities? Why do they want to know? It's simple. Every jurisdiction wants to know what each company does, and they need an elaboration of the business activities. You cannot write a company these days as we did a lot of secretaries did a few years before, because the government houses did not ask. However, today, in according to the whole world uniting and governments talking with different governments, and double taxation agreements being signed through various countries, they all talk with each other and they ask for the business activities. They may correspond information you give to them with other jurisdictions, and they may ask further questions. Therefore, talk to us so we can give you one answer, your business activities, and we'll take it from there if they ask further questions. Next slide. Offshores are used for international trade, imports and exports, direct ownership and asset protection. Here this goes into a bit of a trust element as well. Confidential asset ownership, financial activities and business financing, ownership and use of intellectual property. I'll stop you here and say any questions you have for intellectual property. Eltoma has a legal team here, and we have an approximate of 5 lawyers. So any questions you have for trademarks, intellectual properties, we'll be happy to assist. Investment activities, formation of holding companies. Again, here I'll stop you and advise you that we have international tax planners. If you have companies, if your activities are going to be for a holding company, how to structure them, talk to us again. Attracting foreign investments, attracting trade finance, and legitimate reduction of tax burden. Attracting trade finance, this is obviously done through banks that we work with. If you have questions on this, again, contact us and we can put you in communication with these banks. Next slide. Here we're going to see the difference of onshore, as I previously spoke to it. However, we're going to elaborate on a bit more. Onshore, from English onshore, within their shore. Onshore companies are ordinary companies in jurisdictions with low, high taxation, which are subject to paying tax and are required to keep accounting records and submit financial statements in the country of registration, but under certain conditions can pay reduced taxes. The national tax planning, onshore companies are often used to help apply for double taxation agreements in the agency agreements as well to give greater strength to the business. Okay, so basically what this means, if you're located in the UK, okay, and you're writing a company in the UK, that means it's an onshore company. When we say international, in the second paragraph here, international tax planning and onshore companies are often used to help apply for double taxation agreements. You can have a company that's registered in the UK, and you can have a company that's registered, for example, in Seychelles, which is a tax haven. One company deals with each other, and if there's a double taxation agreement in accordance to where you are a citizen, you can be a citizen in a different company, that will lower your tax burden, as tax will be payable either in Seychelles, if it has business activities in Seychelles, or in the UK. Just depends where your majority of business activities are. Again, don't let this confuse you. Just talk to us what you're thinking of doing, and we'll give you your best options. Following on, characteristics of onshore companies, obligation to keep accounting records and submit financial statements in the country of registration. Here we're thinking of an example of UK or Cyprus. Obligation to pay taxes, tax benefits only in case of conducting certain business activities. Here we're going to see when they say tax benefits only in case of conducting certain business activities. Okay, what this means here, in a lot of jurisdictions, renewable energy, I'm going to use renewable energy as an example. Renewable energy offices, for example, in UK. Alright, so we have offices in UK, and renewable energy is a big subject in the EU these days. Therefore, tax benefits may, in conducting certain business activities, may be applicable if you deal in renewable energy. Do not take this as an advice that exists. I'm just using this as an example. The opportunity to take advantage of double taxation agreements, we touched on this before, and we said about double taxation agreements. Therefore, if the double taxation agreement may prevail in the country that you're a citizen and where your company is registered, therefore this will lower your tax burden if a double taxation agreement exists from where you're a citizen and you have a company from where you have another company. Talk to us, and we'll be happy to look into this scenario in regards to double taxation agreements if we get provided all the correct details. Following on, here we're going to see the big players who drive all this information that we speak about. The OECD, the Organization for Economic Cooperation and Development. Feel free to read up on the OECD and how what I say in this webinar and the information that I provide, how it's matching with the information listed here, as we have to follow this information. Here we're going to see how the OECD categorizes different countries. The first category, which is whitelist, which companies with tax standards and requirements for the exchange of information. So as we spoke about before, how different countries talk with each other, we're going to see that the OECD is the one that pressures them to do this. And when the pressure exists to do this, the companies are regarded as first, second, or third categories. Every country wants to be in the white list. So countries that comply with tax standards and requirements for the exchange of information, e.g. United Kingdom, Cyprus, Isle of Man. Second category, which are grey list, countries that officially took an obligation on the adoption of standards and exchange of tax information, but didn't fully implement them. Example, Anguilla, Andorra, BVI, Belize. And these countries are your normal, typical tax havens. The blacklist countries, countries that have not adopted a tax standard, Costa Rica, Uruguay, and Philippines, are the ones that are always in trouble. And this goes to say, again, with infrastructure, country infrastructure, you will see in countries that are first category, the infrastructure of the country is higher than the ones in the blacklist countries. Why? Because they obtain more money. The blacklist is a list of countries that pursue a policy of unfair tax competition and do not provide information to the tax authorities of other jurisdictions. A lot of people are going to ask, why should be the countries required to do this? Well, that's a big subject to tap into, and we just go along with that. These procedures are there, and we have to comply. If you have real business activities and you want your company to proceed within having a stable bank account, being in a stable jurisdiction, talk to us and we'll provide these options. The blacklist of FATF. What is the FATF? The FATF is mainly the action force behind the OECD. So these go together. It's an intergovernmental organization which is stipulates for the Financial Action Task Force, which is engaged in developing international standards in the field of combating money laundering and financing terrorism, as established in 1989. Sorry. So as you can see, FATF is an old organization. However, we just hear about it now. In 2012, the formation of the blacklist by three categories: countries with the highest level of risk, not cooperating with FATF, and against with international community apply retaliatory measures such as Iran and North Korea. However, we're seeing Iran now very actively complying as they understand the need for international trade, and we can see countries with a high level of risk against which do not measure as they apply. For example, Cuba, Bolivia, and Turkey. Countries whose governments are ready to cooperate but have no real opportunities for interaction are Algeria, Angola, and Cambodia. And this is just mainly due to the militia that may run the country. Furthermore, Russia's blacklist. So Russia and OECD, Russia has a blacklist as well. In accordance to the decree of the Ministry of Finance, Russian Federation, dated on 13th of November 2007, the approval of the list of countries and territories that provide preferential tax, treatment of taxation, and will require disclosure of information on financial transactions for offshore zones. Below we're going to see the most popular jurisdictions as they have categorized them, which are your typical tax havens such as Anguilla, Andorra, Antigua, Barbuda, Aruba, and all these countries that do not let them confuse you, as basically the same. And until the 1st of 2013, there was also Cyprus and Liechtenstein and Mauritius on the list until 2015. We see Malta, Marshall Islands, and etc. Again, if you need any information on the below, this is standard information that can be found anywhere. Please feel free to contact us and we will elaborate on these. Our next slide, which lists to the Ukrainian offshore zones, the most popular offshore zones, including the list of offshore zones in Ukraine. These are the most available known lists: Guernsey, Jersey, Isle of Man, Belize, Andorra, Gibraltar. Nothing much different from the slide before. And then it goes on to Cyprus and Cayman Islands and the Dominica. Again, if you need any information on this, feel free to call us and we'll be happy to elaborate. Now, this is a big question that often gets asked from a lot of people to us: the confidentiality. Will my name be known? Will this, will that? Well, nominee services are available in most of these countries, so take use of them if you do not want your name to appear in the register. The main approaches to providing confidentiality are as follows: at the level of jurisdiction, where there is no public data from the state register of companies, via nominee service, nominee directors, nominee shareholders, individuals, and legal entities for a trust agreement. Okay, so for whoever doesn't know what a nominee is, it's a person that steps into your position as a director or shareholder. When you have a director, the director runs a company. The question may be asked to you is, if I have another person as a director, okay, how can I run the company? Well, a power of attorney is given to you, so this is an important note as well. Some of the company incorporators may not say this to you. Okay, they might say, register this company, will give you the, a nominee, they'll give you the price for the nominee. However, they will not give you a POA. Ask us and we'll also price you on the POA that is needed when you have a nominee. It's mandatory to have a POA if you're going to run the company. Further down, we're going to see for some more information on this. Nominee Services is a person entity, it can be an entity as well. Or, in other words, entity is a company who is formally specified as a shareholder and or director of the company, but in fact is not its owner and or manager. Therefore, this is the answer to some of your questions as well. If you'll be still regarded as the owner of the company, yes, you'll be, and all these documents will be provided by Eltoma with incorporation price if you appoint a nominee. And it will also, if the need for them to be apostilled, we can proceed with that. In practice, nominees, director services, and shareholder services are used to facilitate company registration. Nominee shareholders can be both individuals and legal entities. As I said, I'll be giving you a few free tips today, so here's another free tip. With big banks, they accept the nominee services for individuals. Corporates, they will not accept unless there's a partnership agreement with the company that provides the nominee services. I want to elaborate with which banks we can do this. However, it is doable. So talk to us and we're happy to elaborate. Nominee shareholders can be both individuals and legal entities. Trust deed is always signed. Don't let this confuse you. It's provided by Eltoma with incorporation price, under which the trustee nominee shareholder performs requests on behalf of the principal. Nominee shareholder is a widely used legal term these days. Beneficiary rights are protected by trust law and can be inserted in court. Choosing a country where court disputes can be resolved is very important. The following documents are given to the principal client: the trust deed of declaration and the instrument of transfer of shares. The trust deed or declaration of trust is your document that says that you are the beneficial owner of your company. A lot of companies, again, may not provide this with you with incorporation price. However, at Eltoma, we provide this, which is very important, as it's always requested. I'll give you one more tip. Requested from the banks the declaration of trust of who the real owner is. A nominee director. There is no legal concept of a nominee director. This concept is only used in the practice of offshore business. It is carried forward in onshore business as well. However, it's mainly used in offshore business. Director of the company occupies his position once appointed with all authority and responsibilities stipulated by law. The concept of nominee directorship contravenes to the provisions of law. I'm going to explain on this why. Full restrictions of directors' rights is impossible. You should remember that if the risk of disclosure of confidential information decreases, then the risk of unlawful actions from the nominee director increases. Okay. So as we said before, most of the companies that we incorporate in various jurisdictions are covered by the Corporations Law Act, which is mainly has the provisions from the UK, the English law, case law. Now, with the amendments to laws, the director is in jurisdictions as Cyprus, Singapore, and various others in the UK, has responsibilities to the company, especially in Hong Kong. Now, if you choose to appoint a nominee director, we have a duty of care towards our nominee directors, because they are real people with real lives. All right, so they step into your position as a director for confidentiality reasons. This is to be seriously implemented. They do not go into your position for any legal activities. They just go in for confidentiality reasons, which is for your name not to appear. Therefore, if you're thinking to appoint a nominee in a high-placed jurisdiction, for example, Cyprus, Singapore, or Hong Kong, or the UK, we will provide it. If we see for any manner that you're putting at risk the nominee by not doing your accounting and not paying your renewal fees, which can result in the government chasing after the directors for these and finding them personally liable for these things, pursue as this without your notice. However, if you're incorporating a company in a strict jurisdiction, do not wish to comply with them, and you're just doing it for whatever reason or any illegal activities, be assured that we have to protect our nominees. Further down, nominees director, partial restriction of the director, powers specified in the company articles of association. Important decisions are made during a shareholders meeting. This is what the nominee director step in your position and do. Restricting director's powers is more complicated for companies using a nominee shareholder. In the case of a nominee shareholder, the director is the same person. The following documents are signed: the Nominee Services Agreement, exemption of a nominee director from any liability, the indemnity letter. Therefore, the indemnity letter indemnifies the nominee director for any wrongdoing of your activities. A letter of voluntary resignation from the director with an open date. Why this is provided? This is provided in the corporation price of Eltoma. The letter of voluntary resignation from the director with an open date is provided for one reason: for his protection. For his protection, or if you need to, you as a beneficial owner will have a copy as well. If you need to resign the nominee director at a predetermined date, you have it right there with you. So that's why we say Eltoma Corporate Services is an qualified secretarial service and therefore provides for the provisions in the future and for your past actions. Now let's go and see the beneficial owner, who's going to be most of the people that are listening to me. You will be the beneficial owner. The beneficiary or beneficial owner is a real owner of the company. The beneficiary can be either a real shareholder or the person in whose favor the nominee shareholders hold shares, and in whose interest the nominee director manages the company. Beneficiary can only be a natural person or a particular person. So I'm going to stop you here for a second and take a note. A lot of people ask if a beneficial owner can be a company. No, it cannot. A beneficial owner has to be a sole individual. According to the federal law on counter action to legalization, laundering of proceeds from crime, terrorist financing from the 7th of the 8th, 2001, there's a bit of law information here. Beneficial owner is a natural person. So in regards to people that say, yes, we can appoint a company, other secretaries as a beneficial owner, it's wrong. It's right here for you. The beneficial owner is a natural person who ultimately, directly or indirectly through third parties, owns more than 25% in the capital of the legal entity or has the ability to control the actions of this legal entity. Okay, here we can see the number of 25%. That means more than one person can be a beneficial owner. So if you're a husband and wife, beneficial owner can come in place and you can have a nominee director and nominee shareholder. The nominee shareholder steps into your position. However, you're the real owner. It's your wife with 50 and 50 shares. Next slide. The beneficial owner of the company, despite the use of nominee directors, shall hold the services, actually manage his company that is incorporated. And when I tell you that appears advised by the OECD, as we saw before, and FATFA, procedures have changed. Therefore, procedures aimed at establishing the identity of the client as well as checking and examining client activities are called due diligence and KYC. The idea is, one, that procedures have changed, and I'm telling you straight out now that without the provision of these documents, and whoever says that these documents are not needed is doing something wrong. So without the provision of these documents, nothing can happen to incorporate the company. Due diligence is a complex procedure checking the client profile associated with the requirements to identify and assess all the risks involved. KYC, now your client is a term signifying the need to identify, establish the client identity. Therefore, what this says here is basically to incorporate a company or a bank account, this process has to be passed. If you speak to us, it's a very easy task for us to be done as we do it day in, day out, and it's just a provision of documents. If you're in the process of or the understanding that these documents not be provided to us to incorporate a company, then I'd like to invite you to just please obtain the documents, which is basically your passport, ID, utility bill, they're not older than 30 days, and a second proof of ID as we said it, a bank reference letter if you're going for a bank account, and just a basic CV that's signed underneath by yourself. Very easy documents, very easy to incorporate your company, and very easy to start your dreams. Just a few documents required. Documents for company registration for legal entities is a company registration documents, and they start from the certificate of good standing for companies more than 1 year old, and for individuals, what is required is proof of ID, proof of address, as we saw before. So here we're going to see documents of company registration for legal entities when it says this, if we're going to appoint a legal entity as a director or shareholder. Again, I'll remind you, they cannot step into your position as a beneficial owner. So there's four parties. There is the beneficial owner, which will be yourselves, the director, which we can have a nominee. There is a shareholder, we can also have a nominee, and the fourth party, what no one mentioned, again, and I always say is very important, is the secretary, which is Eltoma Corporate Services. For individuals, what will be required is a proof of ID and, as I said, a proof of address. Further on, it goes to explain what a certificate of incumbency is. For you that are going to appoint a company as a shareholder or director, you'll be aware of what a certificate of incumbency is, which is basically a document that stipulates all the director shareholders' information, who they are, on which company they are on, and it's required when you're going to appoint a company. The certificate might be requested by the banks of the service of company or company contractors on a regular basis. A free tip here is every year, if you have a company, every Tumu bank will request a certificate of incumbency, or they can request a certificate of good standing. Why? Because they want to see that you renew your company every year. Why? Because they're in Europe and they have to follow the OECD rules, and they like to see that a company is renewed every year. Furthermore, documents required from individuals for company registration, as we saw, is international passport ID, internal passport, and driving license. The proof of address can be utility bill not under the 3 months, internal passport for Russian and Ukrainian citizens or Indian citizens, where the proof of address is stipulated on the passport. If this corresponds for your country as well, feel free to provide it with an additional 2 IDs. Bank reference letters, bank statements, other documents with the name, surname, and the primary residence address are indicated. Again, don't be lazy to provide these documents. If you have a bank statement, it's more acceptable, or a utility bill that's from a governmental organization. Maintenance of foreign companies, which is registration of government fees, legislation of documents, nominee service when used, registration office, secretary, keeping accounting records, audit, annual return, taxes, cost of changing the company structure, and the documents that are required for conducting business. This slide is important to me and should be important to you, because when you have a foreign company, this is the procedures that you're going to follow. This is everything that you need to know about a company in one slide. And again, don't let this confuse you or scare you, because you have Eltoma Corporate Service as your secretary, and we'll inform you about all these. It's not hard to follow all these. We just need an open line of communication. When you ever get a chance, we'll notify you when the dates come due. Just shoot us out the information and we'll take it from there. Company maintenance, starting from the 2nd year of offshore companies, are obliged to pay a fixed annual fee, the size of which is set by the local authorities. So this depends on the jurisdiction the company is incorporated in. The payment in fees required for the continuous existence of the company, the status of good standing, keeping it in the administrative registrar of companies. Here I'm going to give you another free tip, which is all the banks in the world now, they like to see that the companies are in good standing. Before I gave you an example of a tool that they request for a certificate of good standing or a certificate of incumbency for each company each year. I'd like to tell you now that a company, if it's not in good standing, it's illegal for us as a qualified secretary to advise the banks that it is. Therefore, we will not, because the fines are hefty, and just to cover one company, it will not be worth it. However, we'll be in communication with you a long time before the company's incorporation renewal is due. Second point here, in addition to the annual fee, you must also pay for secretarial services, which is Eltoma's fees, provision of registered address and nominee services if used. All indicated costs constitute to the cost of annual maintenance of the offshore company. Another important point here is, with your renewal fees for your company, the secretarial fees are also included. In other words, Eltoma's fees for the year. We do not do various jobs for you and then bill you, so you get a heart attack what the bill comes up to. For each service that you require, we'll bill you individually. Therefore, you know the expenses and you know the liquidity within your in your account for the whole year. The renewal costs will be with the Secretarial Service. For example, if you need a resolution to be passed for a specific bank account or a special POA, or something like that, we'll advise the price before we bill your account. Your account will not be billed without monies in it. Further down, company tax residency. We touched on this briefly before, which is most countries impose taxes upon citizens and legal entities, and many jurisdictions charge taxes for the taxpayers, including legal entities, in accordance with the worldwide income on the basis of the citizenship resident. We spoke about this in the DTAs before. What makes a company a tax resident in a particular country is a big question. The company is considered to be resident of the country of registration if its control center, this is the most important part of this slide, if its control center, the place of effective management, is located in the country. Therefore, if you have a company that's registered in Cyprus and you're overseas, if you would like its management to be done within Cyprus, if you're visiting us once in a while, we'll be happy to conduct this for you. And there may be tax benefits depending on your activity, how we spoke about before. However, in order to qualify all these, again, you have to communicate with us and talk to us, and we'll be happy to communicate. Furthermore, management and control of a foreign company. Management control test is a main test of many countries. According to this test, the management of a company is recognized to be carried out in one country, then the company which is managed from the country is a tax resident of such country. Here comes the OECD again. Test on effective company management, place of the board of directors, meeting registered in the register of directors, location of the executive body of the company, location of the main management or company offices. Here, as we can see, place of the board of directors meeting, which is organized by Eltoma for each company that needs to provide accounting records to the respective offices. Registered in the register of directors, Nominee Services. This is a free tip for you, which if you need to understand how to do this. Furthermore, the tax residence certificate is a document that confirms presence or absence of the company tax residence in the country and its registration. Here it's important to note that if, as I said before, if you live in a country where you have another onshore company, you need the tax residence certificate. This is provided by Eltoma upon your request. It costs very minimum fees depending on jurisdiction. However, the certificate will be needed in order to avoid double taxation. Therefore, that's why we have double taxation agreements. Country tax residents can enjoy the benefits granted by the local tax legislation. Tax residents can enjoy the benefits as registered in accordance with the DTA agreement. Furthermore, here we're going to see another table, parameters of comparison income tax and using in tax planning. Cyprus, Singapore, and Hong Kong, 3 tables. In Cyprus, the tax is 12.5%. Cyprus tax residents are taxed on all income earned anywhere in the world. Companies and individuals who are not tax residents pay taxes only on income received in Cyprus. There you go, that's an important note there. So if you understand that. Using in tax planning, I wish you could perform a screenshot here because it's very informative table. Convenient to work within the EU counterparts, use of double taxation agreements. In Singapore, 17% of territorial principal taxation. To apply zero rate, you must have an account outside of Singapore. Very important there to note. Operate and earn income outside of Singapore. Again, very important to note. It is possible to have both offshore and onshore activities. Divide the income into taxable and exempted one. Again, very important to note. Possibility to using in tax planning, possibility to divide profits to be taxed at 0 and 17%, use of double taxation agreements. And then we go on to Hong Kong, which is a bit more high tax, which the territorial principle of taxation applies. To apply 0% if you're not carrying out activities within Hong Kong, and it is possible to divide the activities onshore and offshore. Hong Kong, using in tax planning, is a center of receiving profits. It is to use a territorial principle of taxation properly. A lot of people are being diverted from Hong Kong now. So please be aware by Hong Kong due to the hardness of opening up a bank account. If you need a bank account in that within Asia, I prefer Singapore. Let's move on. Company liquidation. As I said again, we have a whole team for company liquidation because we have a legal team here in Eltoma. the two types of company liquidation that can be applied. There's a complete liquidation, which can be voluntary, a joint decision of directors and shareholders. This is the most commonly used liquidation form today, or forced by court order. In order for it to be forced, that means you're not paying your creditors, your suppliers, and they're taking you to court for liquidation. Partial liquidation or strike off in tax, which is usually in tax havens. However, in tax havens, liquidation does also exist. In tax havens, Seychelles, BVI, Belize, and some others, companies automatically excluded from the register of companies after failing to pay their annual renewal fees. And guess what? If you need to reinstate it, more fees are payable. That's why I said again at the start of our webinar that sometimes when you incorporate a company, the tax that you may pay is lower than the fees that may be payable in certain jurisdictions. To reinstate a company at the registrar in the BVI, the company can be restored within 10 years. In Seychelles, 3 years. Belize, within 3 years. Singapore, it is 15 years. So again, I'd like to bring your attention to this slide. It's very important. As when I said, when we protect our nominees and in the event that you do not comply or you do not do your accounting records within jurisdictions as Singapore, Hong Kong, or Cyprus, where the nominee as a director can be found liable, your name as the BO, when we remove the nominee, can stay there for 10, 3, or 15 years. In Hong Kong, as OECD, the Organization for Economic Cooperation and Development, this is going to be your best friend if you have a foreign company or onshore company or deal international. The convention was concluded in Strasbourg on the 25th of January 1998 and it entered into force in 1995. The determination of tax information, the teacher exchange and information that's pursued to be important for the administration and enforcement of laws. Why I'm saying this, why is this slide up, is for your information that your company as an international as an international player, company player, you have to comply with certain rules. The exchange of information will be carried out once a year. Each government which signed this agreement shall request information on the non-resident accounts from financial institutions of this country. Let's go and see further down. Some of the last slides again for the OECD, all EU countries as well as Liechtenstein, Iceland, Israel, Turkey, etc. Australia. Here we're going to see all the countries that have a high infrastructure. Again, because taxes are paid within these countries. The first test of automatic exchange will take place in September 2017. So take note of this if you're international. If you have provisions to have an international company, currently the following important offshore jurisdictions don't participate. However, they will be forced to participate, as we all know, as we're seeing more and more countries just participating. I'd like to thank you for listening up on our webinar here, and I'd like to invite you to go back and see all the information that we saw today. Eltoma Corporate Services, as I noted at the start, provides a lot of services except from company formation and information to our clients. And this information is the registration and maintenance of companies in more than 35 jurisdictions, the creation and restructuring of international holding structures, immigration services, talk to us if you need anything like that, accounting, auditing, and preparation of financial reporting. Again, I'd like to stop here and advise you that even if you have a company that's Eltoma is not a secretary, call us, get a quote. You might be more competitive. The more shopping around you do, the better prices you get, the better service that you get. The opening of corporate bank accounts, legal services, assistance in receiving licenses, registration of trademarks, holding seminars and webinars as I am today. I'd like to thank you for listening up on me. And if you need to contact us, feel free to contact me, Andrew Aristides at eltoma-global.com. Here you'll see our international offices. In the event that you have a company and you'd like to contact us, we have companies in 3 different time zones. Therefore, if you need important information, you can contact us either in Singapore, in Hong Kong, in Cyprus, soon to be in the UK, and in Russia. Therefore, contact us, and the information you need, the more questions that you ask, the better answers that you'll get. I'd like to thank you again for being with us today. And any information that you need, Again, feel free to contact us. Thank you. Enjoy.